Well, look, the only thing that is embarrassing to me about this is that because the prosecution has been stopped, people think that there is something embarrassing for me if the prosecution goes ahead, when it's quite the opposite. I gave a witness statement to the Royal Gibraltar Police, so I was available, ready and willing to give evidence for the benefit of the court, because I'm an officer of the court. I'm a barrister in practice when I'm not Chief Minister, and so therefore I believe that every citizen owes a duty to share whatever information they may have about something which is relevant to court proceedings with the court and make themselves available. So as far as I'm concerned, the government would have happily, and I in particular would have happily, provided all the information that I had about this matter to the court and put it in the public domain. The decision that there is a reason here to act to enter a nolle prosequi is a decision of the Attorney General, who has made that decision completely at arm's length and independently of the government, and has then informed me as a leader of the government and the leader of the opposition and other parliamentarians of his decision and the reasons for it.
Given the nature of the companies involved, is the issue of public interest one of national security?
Well, you know what it is that the companies involved do. You know that they're involved in issues relating to access to Gibraltar and how we control access to Gibraltar. So therefore, it's clear that there is a national security issue in play, and that is one of the reasons that has led to the decision being made, as far as I understand it.
And you're satisfied with the reasoning given?
I am satisfied with the reasoning given. I think that if you look at the interview that the Leader of the Opposition gave you yesterday and the statements that they've given, they're not challenging that. They're saying that the consequence of that is a benefit to me, when in fact there is no benefit to me. The embarrassment to me only arises because of the nolle prosequi. If this case had gone forward, people would have seen that all of the decisions that I have made have been the opposite of designed to create, for example, as Keith Asabaldi scandalously insinuates in his interview with you, that I was somehow trying to enrich myself and the partners of Hassan's, who ironically include Daniel Feetham, one of his MPs, by making a decision that was favourable to Hassan's as a shareholder of 36 North. In fact, what you would have seen if the case had gone to trial was that it was me that decided that 36 North should not get the contract and it should stay with Bland's. So I made the decision to stop what might have been the benefit to Hassan's and the partners of Hassan's, including Daniel Feetham, a member of the GSD, and to keep the contract with Bland Ltd. So as I tell you, people like to spin these conspiracy theories, and actually the thing that is actually happening is the opposite of what the conspiracy theorists might be suggesting.
Michael Yamas works very closely with the government on issues such as Brexit, for example. You've said there's been no consultation with the government. Has the government not even then been briefed in the process running up to the nolle prosequi?
Absolutely, 100%. Look, I can tell you that I have a very close relationship with Michael Yamas. I consider him a friend, apart from a professional colleague, but we are professional colleagues, and therefore, when I make decisions that affect his department, I make them on an arm's length basis with submissions as to budgets, for example, etc. But I make those decisions with the financial secretary and with the rest of the cabinet. And when he makes decisions, and when Christian Roca makes decisions about prosecutions, etc., they make those decisions independently and without having regard to the government in any respect whatsoever, because there is a sacrosanct wall, not even a flimsy barrier, there's a sacrosanct wall of difference between and division between the government as a political entity and prosecutorial decisions. That's what makes Gibraltar, like the UK, a place where you do not have to have any fear that you will be prosecuted or persecuted because the government might or might not like you, because decisions about prosecutions and any matters relating to the legal aspect of what the government does are taken in the criminal sphere by the police, by the Director of Public Prosecutions, and ultimately by the Attorney General. The government runs civil cases that affect the government, because that affects directly the public purse, and those are civil commercial matters, but nothing to do with the criminal law.
The Attorney General has decided not to prosecute the defendants in a high-profile fraud case by way of a rarely used legal device, and has not given the reason why to the public except to say that it's in their best interests. Doesn't this risk undermining people's trust in the fairness of the justice system and transparency at the highest levels?
Well, look, I don't have to defend the decision of the Attorney General because it's his decision. And therefore, as I've told you, in fact, it would be easier for me politically if this case had gone ahead and I had given my evidence, because then everybody would know the facts and they would see that I acted entirely properly. But what I would tell you is this. I've seen the Leader of the Opposition and I've seen the Leader of Together Gibraltar say that the fact that a noli prosequi has been entered by the Attorney General is an attack on democracy, and that it is in some way going to undo the way that our society functions. You've got to understand, a noli prosequi is a procedure which is established in the United Kingdom, which is the cradle of Western parliamentary democracy. It is a procedure that exists in the UK, and it exists here for that reason. And although it is very, very sparingly used, when it is used for a good reason, which is a non-political reason, although in the United Kingdom, the Attorney General is a member of Parliament, sits in the cabinet, and is answerable, therefore, with all other ministers for collective responsibility with the Prime Minister. Here, we're in an even better position, where the Attorney General is entirely arm's length and independent of the government of Gibraltar in its political guise. So we have even more safeguards here, and therefore people should have even more confidence here. Look, we all, when we're in opposition, sin of trying to use every opportunity to damage the government. Perhaps if I was Keith Asabaldi, I would be also trying to forget all my legal training and make these spurious allegations just for the sake of damaging Fabian Picardo's otherwise unimpeachable integrity. Perhaps I would fall into that trap, and perhaps I fell into that trap when I was Leader of the Opposition in the context of Peter Caruana, and maybe that's just the cut and thrust of politics. But look, this is a hugely important issue for getting the case in question and for getting the characters in question. People need to have complete confidence in the fact that the criminal justice system in Gibraltar is being administered in the most exemplary fashion by a man who is an extraordinary professional, who gave us the European vote, who saw us find our membership of UEFA and of FIFA, a truly committed Gibraltarian, who I would not be able to influence, although he's one of my closest collaborators in the negotiation with Brexit and a good personal friend. I would not be able to influence him if I asked him improperly to do anything. People need to have that confidence.
Isn't the net result that three men against whom the prosecution says it has a case will not get a fair trial and their day in court?
Well, this is the whole point of a noli prosequi. I mean, I've heard people say in the part of the public debate and on social media that if the Attorney General entered a noli prosequi, how could he also say that there was evidence to take the matter to court? Well, that is exactly the nature of a noli prosequi. You don't enter a noli prosequi if there is no evidence to take the matter to court, and if there is, in the judgment of the DPP, no evidence which potentially could result in a conviction. The fact that there is, in the view of the DPP, such evidence doesn't mean that there's going to be a conviction, because that is always up to a judge and a jury if the judge leaves the case to the jury. But it's only in those circumstances that a noli prosequi is relevant, because some of the facts might, for whatever reason the Attorney General may determine, expose issues of national security or the public interest in some way. And that's the decision that he has made. And that is what the whole system is designed for. And this is the proper operation of the system, not some, as Ms. Hassan Naun has hyperbolically suggested, some working of the system which is undoing it and undoing our democracy. Far from it. These are the foundations of our democracy, which are complex and difficult to understand, but we have to see them in operation to understand how these difficult decisions are the ones that we provide for in our system of laws and in our system of democracy.
Can the government confirm whether it was a complainant in the case at any point?
The government was not a complainant in the case. I know that even this factual issue has become an issue of controversy. I've provided evidence in the case because, as I said, I'm an officer of the court, and whenever I see something or I'm involved in anything which the court may be inquiring into, I'm 100% available for the court to hear what I have to say, and I would encourage every citizen to always take that attitude to anything that they may see or know about anything that may be examined by a court. But we were not a complainant. We might have been a complainant, and we asked for the information to be provided to us so that we could determine whether we would be a complainant, but we were not able to make a determination that enabled us to take a view to become a complainant.
It's been suggested by the GSD, among others, that there were other ways to deal with this case. For example, a ruling to hear part of the proceedings in private or under protective measures for the giving of sensitive evidence. As a lawyer and a QC yourself, would this not have been a way for the case to actually have proceeded?
Well, there are potentially many ways for the case to have proceeded. Potentially with hearings in private, potentially with full hearings in camera. Then people would have said that that was justice denied, because justice must be in public to be justice. And in the UK, cases of hearings in camera about the highest issues of national security involving terrorism, for example, and you might not have been able to cross the threshold of this particular national interest having to be held in camera, because a judge has a different consideration to a consideration that the government may have about national security interests. So all of those things could have been involved. I absolutely agree with my opposition colleagues in that respect, but the person who makes those decisions, who has all of the facts, because we don't have all of the facts, and who is making the decision with all of the facts in hand, a little like the Carolina case, where the decision being questioned or impugned is one of the person who has all of the facts. We have only the facts that we read in the media, not all of the facts. Those decisions have to be made by the persons and individuals who have all of those facts. In this case, in the chain, it would be the police in the first instance, the DPP in the next instance, and then ultimately the Attorney General.
You say speculation as to whether this case and the retirement of Ian McGrail are linked will be brought to a close by the inquiry. Are you then stating categorically that there is no link?
Look, what I'm saying is that that link has been made by the leader of the opposition. And today he said that I have been pushed into this inquiry because I didn't want to do it. Well, look, I'm the one who announced there would be an inquiry. We haven't been able to do it for 19 months, he says, but that demonstrates we didn't want to do it. Well, look, I'll be very open with you. We haven't been able to do it for something that the leader of the opposition might not have heard of, which is a worldwide pandemic, which made it almost impossible to guarantee that the judge would be able to come from the UK to Gibraltar, spend the time he needed to spend here, be able to move backwards and forwards without any interference with his travel, and now that appears to be clearing up, and we hope to be able to therefore get this inquiry on, and indeed to get the COVID inquiry on very soon, in some weeks or months, as the pressure on the GHA starts to lift, and we all hope that Omicron is the beginning of the end of the pandemic. That's the reality of what's happening here. But I'll tell you more. The link that Keith Asopaldi drew yesterday in his press release and in the interview with GBC was very clear. He said that there had to be an inquiry into what had happened with Ian McGrail, because if the Chief Minister or Minister had exercised constitutional or statutory powers, then this had to be looked into, and therefore the inquiry was appropriate, and I was trying to avoid it. First of all, far from it, I'm the one who's going to convene the inquiry. I said so in Parliament, although I don't think it's necessary, because Ian McGrail in the end resigned, and I have tried in this period, because of the cost of COVID, to see whether it was possible to persuade Mr. McGrail not to proceed with this inquiry. He hasn't wanted to. He wants to go ahead with the inquiry, so we'll go ahead with the inquiry at huge public cost to the taxpayer, which we can ill afford at the moment. The last inquiry, the Dr. Hidaldi inquiry, Keith Asopaldi acted for the government and charged about £3 million. So let me just be clear that it is absolutely going to happen, but there is no constitutional or statutory power that the Chief Minister of Gibraltar has in respect of the resignation of a Commissioner of Police or retirement of a Commissioner of Police. So if Keith Asopaldi is saying we have to have the inquiry into Mr. McGrail's early retirement as Commissioner of Police because the Chief Minister has therefore exercised some constitutional or statutory power, he has got it completely wrong. He hasn't read the law. The 2006 Constitution, which he says he is the author of, contains no power to a Chief Minister to compel or otherwise seek the retirement or resignation of a Commissioner of Police. And there is no statute, in particular the Police Act, that provides a statutory power for a Chief Minister or any other minister that I might be able to influence to have such an influence upon the early retirement or resignation of a Commissioner of Police. So on these issues, where they're trying to spin up a massive conspiracy theory and trying to get people to lose faith in the operation of justice in Gibraltar, in the political system in Gibraltar, in the tenor of our democracy in Gibraltar, the base card on which they've built this house of cards is that the Chief Minister has constitutional statutory power to influence the retirement of a Commissioner of Police, and I have done so, and this must be looked into. And in fact, I have no such constitutional statutory power, and anybody can look at the Police Act and can look at the Constitution and will reach the same conclusion. This is not complex, it's not difficult. It's very easy law to understand, and I'm very surprised that the leader of the opposition, the leading counsel himself, has failed to understand the law in this respect.